Hello, everyone, and welcome to the Lawyers and Mediators International Show and podcast from InstantMediations.com. It's where we discuss law and conflict resolution topics to educate both professionals and everyday people. Hi again, I'm Mac Pierre-Louis, attorney, mediator, and arbitrator, qualified to mediate cases in Texas and Florida.
And I am Natalia Olowska, advocate, mediator, and arbitrator based in Warsaw, Poland.
And I'm Tye Bourdony, full-time mediator and primary trainer in Orlando, Florida.
In today's edition of our podcast with Tye Bourdony, called Florida Mediator Roundtable with Tye Bourdony, we are going to discuss an interesting topic of what kind of cases can be resolved at mediation without lawyers. And if you do not currently have a lawyer, please tune in to know something more, because there might be cases where you will be quite well off without a lawyer, others where you will need one, and some where you just need lawyer's advice, either prior to the mediation or within it. And so our guest will be bringing this topic closer to our listeners and viewers.
All right. So, Tye, on today's topic, we're discussing some types of cases that can be done at mediation without lawyers, without attorneys.
Yeah.
And this connects back to the topic we had done before, which was how pro se people without lawyers do mediation themselves. And we had talked a little bit about this before, but now we're talking specifically about the kinds of cases that we might frequently see. Yeah. So from your point of view, go ahead and give us some different types of cases that frequently have no lawyers.
Right. So the easiest ones that I think I'm alluding to right now are family cases, right? Either divorce, paternity, some kind of modification, child support, that kind of thing. Not all, right? The case has to be ready or the right kind of case to be mediated without lawyers, right? And then I would think the other easy ones would be types of insurance cases, because those happen quite frequently, specifically like homeowners insurance cases, right? Those kinds of things, denied claims, those are typically mediated before anything is filed. Mediation cases for family, likewise, they can be before something is filed, or they can be after something has been filed. Those are two easy ones, but then there's also debt collection cases, right? So as happens oftentimes, at least in the States, I don't know what the process is like in Europe and or Poland. Natalia can tell us, but sometimes people don't pay their debts, and a year and a half to 3 years later, sometimes more, they get sued. And typically when they get sued, it's through small claims. And a lot of times those are third-party debt purchasers. So it's not even the person or the entity that originally purchased that originally extended you the credit or who you got it from, but someone else who bought it dirt cheap and now is suing you for the entire amount. So at least those three are really good places to start that I see regularly, but there are many others. But today, I guess we can start with those three.
Here in Poland, however, we believe that when you resolve case without a lawyer, especially family law cases, and this is what judges do to us as lawyers, they send cases to mediation specifically saying that you have to go there without lawyers, because there is a common belief that mediation can help start hearing each other better, start new ways of communication, and a good mediator can introduce this thing better than anything else. And
that's amazing that it's without attorneys.
Yeah. What do you think, guys? Should people try to resolve the cases without lawyers?
Well, was there Mac, you were reminding me, a third one that I forgot to say that I was alluding to?
I know you mentioned family law cases.
Family, insurance, and debt collection.
Small claims.
Small claims, okay. Debt collection. That could be a lot of other things. It could be anything in small claims, landlord-tenant. It could be, pick something. If it's small claims, it's because the amount of controversy is less than a certain amount of money, right? So you go from county to circuit to, family is a different entity, but different amounts of controversy. So in Florida, for instance, when I was in small claims, it used to be $8,000, $5,000, $8,000. That's gone up, and it's going to be going up again now, right? So, but small claims right now is like $8,000 to $15,000 in Florida, for instance. It's going to be different, I'm sure, in Texas. I'm sure that there are different amounts in controversy. So when we say small claims, debt collection is going to fit within there, and that's what people typically get caught. They have to go to court because they got something in the mail. But it could be any one of a number of things, right? If you're getting evicted, and those are coming, that could be a landlord-tenant, homeowners associations, right? Those can come that way. But I thought I'd address debt collection just because that's typically the bulk of them, but it can be any one of a number of things. So thank you for clarifying that.
So back to my question then, should people try to resolve these cases without lawyers?
That's a great question. And the answer is maybe, right? And so, why is it a maybe? One, I would tell you, it's never a bad idea to consult with an attorney, right? There's a difference, however, between consulting with an attorney and hiring an attorney. Hiring an attorney, you got to give a retainer. Consulting with an attorney, you have to pay, an hour fee or something like that. By the same token, you can also sometimes local bar associations in the States, right? So if I'm talking the Ninth Circuit, Orange County, Orlando, you can contact the Orlando County Bar Association and they will have an attorney referral program. So someone can do that, right? You can get like an hour for $50 or $75. I'm sure, Mac, you'd be able to tell us what's that like in Texas. But the point is, when you go to court, you got to know what to say, how to say it, when to say it, what not to say, right? And people don't do it on a regular basis. And so why would they know? So it's really good to have your ducks in order, know what it is you're talking about, know what the issues are, and be able to speak to it. And so sometimes you can do it yourself if you're knowledgeable, or if, boy, you're just a heck of a fighter and you did a lot of good research. But most people wouldn't know. So consult with somebody. Now, after you consult with somebody, that attorney is going to let you know, listen, you can probably do this on your own, or they're going to tell you, ooh, you might have to worry about this. And so then the person has to consider, do I do it on myself, armed with knowledge from an attorney, or do I hire an attorney and bring them with me? Where do I have a better chance? And then the question is, well, if I'm going to hire an attorney, how much is it going to be? Look, if it's a small debt, $1,000, $2,000, $3,000, $4,000, how much are you paying for the attorney? And then how much you have to pay for the debt, right? Whereas if it's a larger debt, and is it worthwhile to hire someone, and are you still saving money after they charge you what the fee is? Now, so sometimes consulting, getting the knowledge, and then going yourself can be done. And then if you have to go to court, you can hire them just for court. Or sometimes you can hire an attorney just for mediation, especially in family cases. But the question is, every case is different. So it's case by case, right? In this case, should I start off with a consultation? Probably. Great idea. At the very least, do a lot of research, but you can never go wrong getting a consultation from an attorney in that field of law who can tell you what you need to know so that you can negotiate well at mediation, right? Because if you don't know what the issues are, and if you don't know what your best case scenario and your worst case scenario is, how good are you going to be able to negotiate? Because that's what you're doing at mediation, right? So you want to have the best foot forward in mediation. And so if you know everything you need to know and you're confident and you think you got it, go ahead. But you're probably better off with some knowledge, and knowledge is power. And you can get knowledge on that case from an attorney who's licensed in that, in that state and who practices in that jurisdiction. That kind of law is the long answer to a very long question, if you think about it.
Yeah, the way I would answer it for this jurisdiction that I currently live in, I would recommend people go talk to an attorney. Again, if they don't bring one with them, that's fine, but they should at least consult one so they can know what their options are, because the mediator can't give legal advice.
Right.
Here in Houston, we have the Houston Bar Association. There's different groups, but there's Houston Volunteer Lawyers. The Houston Volunteer Lawyers program, which the website is makejusticehappen.org, makejusticehappen.org. But Houston Volunteer Lawyers program, they basically let you come to them and give free consultations. And
Great.
Perhaps if somebody's pro se and they want to go and speak, at a mediation office with the other side, it might be smart to at least pick a lawyer's brain, or pay somebody professionally, if they really know the issues that you care about. But before I hand over to Natalia, there was something Natalia and I had done maybe about a couple of years ago. We did a video out in Warsaw, actually, where we asked the same question. And I remember, having this little debate about whether or not lawyers should come to a mediation. And over there in her jurisdiction, there's a lot of times you don't see lawyers at mediation. Here in Houston, anyway, in Texas, I mean, you always see an attorney at mediation if the parties have one. But in her jurisdiction, and Natalia can speak more about this, sometimes the people have lawyers, but the rule is people don't go with the lawyers. They go themselves. They go alone because it's their case, and the mediator's job is just to help them make it happen. So I think lawyers can sometimes be problematic to a mediation case because they're putting one hat on, which is fighting and zealous representation, representing their client, and sometimes they're not really helping clients resolve their case.
I've seen both, but there's a point there. There's a point there.
Yes, and let me tell you that it's not just the judges, as I was telling you before, who believe that there can be magic that happens in mediation when people finally see each other, hear each other through the mediator, then can reestablish some sort of communication, which is particularly important when people have kids. And after mediation, they need to live on a daily basis together, bringing up the same kid or kids, even if they live separate lives. Communication, which is being established by mediation, can help. However, I need to tell you that mediators here in Poland believe that attorney can spoil every single mediation. I was attending a mediators conference in Warsaw when I was also a speaker, and I actually had this topic, advocate, so me, in mediation. And I was attacked by so many mediators who were saying, no, you need to understand that you're wearing two different hats. The hat of the advocate, so the attorney, is to fight in the court. The hat in mediation is to try to bring people into settlement. However, advocacy ethical rules say you need to bring people to settlement. So a part of our job is to understand that. But yes, I do believe that certain people, certain attorneys don't have this mindset. And I can tell you that as a joke, but that is absolutely real. I remember standing in front of the courtroom in a very difficult case with many possible issues, property division, children, schools, all that. And I approached my opposing counsel and I asked him, would there be a chance that we could go in mediation and solve this case? And the guy answers, I don't believe in mediation. And I say, why? Because my wife is a mediator.
That's a great joke, funny story. I love it.
Actually, it's absolutely real.
So. At home, it's because you're not mediating. Okay. That's funny. That's really funny. Wow. So I've seen both, right? I have been in mediations where the attorneys do a great job. But I've been in plenty of mediations where, sometimes, yes, they're fighting more than trying to come, to agreement. I would tell you it's case by case, right? And it depends on the attorneys as well. But a good mediator can still, it just may take a little longer. But again, case by case. I can see that, but I would, if people have attorneys and they get very good advice and they're prepared and then they go in, sure, why not? But the question is, are you able to do it on your own? What about those folks who just get really nervous, or they don't do well, like they're not good talkers, or they're very shy? What about them? Are they going to do well? Sometimes you need somebody. And so that pendulum can swing very far in either direction. So it's kind of tough. I think it's case by case. And I think, you never know what you're going to get.
And this is coming from the perspective of three lawyers, right? All three of us are attorneys as well.
Actually, I'm after law school, I became a full-time mediator. And so I only practice law. I only practice mediation. I'm not licensed to litigate, right? I'm only certified to mediate. So I'm actually not, after law school, I became one of the good guy mediators, but I'm not a practicing attorney technically.
Yeah, well, technically, thank you so much for that clarification.
Imagine if I didn't, I'd be in trouble.
Yeah, no, but Natalia and I, we're frequently in the courtroom, and obviously, I'm actually trying to do less than that and do more mediations because that's where my passion is these days. But this is coming from a perspective of lawyers, meaning we're not trashing lawyers and saying, hey, don't bring your attorney to mediation, that it's going to ruin it. It's just that we've seen the good, the bad, and the ugly. And some of the ugly I've seen where the lawyer basically is, bumping their fist on the table, on the desk, agreeing to nothing, being totally unreasonable, even though the party is right there really wanting to get a negotiated settlement because they don't want to keep dragging out this. And so this is my speculation. It may be about money, for the attorney.
Sometimes it is.
It might be about just power by the attorney.
Sometimes
It might be that the attorney wants to show the other side. There's different reasons as to why the attorney might just be one of the good guys and they're just really not wanting their client to be stuck with a really bad deal, okay, as they see it, and they want to go ahead and take it to court. But
and in that case, they're right to do it the way they're doing it. That's
Absolutely.
why I say it's case by case. In the States, sometimes a mediation needs an attorney, sometimes it doesn't. And we understand how it is in Poland. You never have an attorney, but I would hope that they can consult with their attorney clearly and go in prepared. Yeah.
Oh, absolutely. And also sometimes, because the specifics in Poland is also that it is the mediator who drafts the mediation agreement afterwards.
It should be that way everywhere.
It can have so many different sophisticated issues sometimes that it's better that it's overviewed by lawyers, because on certain occasions it will be just enough that the mediation agreement is there, it will be just approved by the court. But for example, in case of property cases, we need to have a separate settlement in the court or done by the notary. So it is being believed that mediation agreement is not enough in terms of form, of a solemn form that will transfer the legal title. However, one more thing I need to tell you, being an advocate and mediator, is that I am now being a mediator-shamed advocate, because since I bear it very proudly on my letterhead, and it clearly says advocate and mediator, so attorney and mediator, I get legal petitions, claims, or even statements in the court which says, but you shouldn't be saying that because you are also a mediator. Just like being advocate just like that doesn't really, entitles me to do more. Whereas when I am also a mediator, I need to mitigate myself. This is how people perceive it, which is in a way funny.
We have interesting dynamics with respect to how mediators should talk and when should about themselves, and so I think the dynamics are interesting. We just have we have a little bit of a different spin on it, but at the heart, the most important thing is really what we're talking about is at mediation, can parties without attorneys do just as good and or a better job as mediations with attorneys? Sometimes is the answer, right? And the more prepared you are for that mediation, the better you can do, right? And your mediator helps, right? Like having a good mediator, a good experienced mediator, a good empathetic mediator, someone with good high emotional intelligence, who cares, who's neutral, can get the parties through the process as well. So at least get a consultation, right? And be prepared for mediation. But if we're talking family cases, if we're talking insurance cases, if we're talking debt collection cases, and there are other kinds, yes, you can do them without. But if you go to a debt collection case, if you don't know what kind of offers are going to be accepted, if you don't know what a good defense is, if you don't know certain things, you're going to have a tough time. If you don't know what to say with an insurance adjuster, maybe you need a public adjuster. If you don't, seek your advice, get your knowledge, and then if you think you can do it, go to mediation. If not, get an attorney. It would be my answer. And I know we're short on time. We obviously, every time we do this, we're going to talk more and we're going to keep deep diving this issue.
Yes. And I guess my takeaways from this is, anybody can come and do their own case. You are able to represent yourself. Just do it competently, and come prepared with as much knowledge and information as possible. Because remember, you can't, as a pro se non-represented person, can't depend on the mediator to serve as your lawyer. Okay. And most mediators want a level playing field. You can't force people into a certain kind of agreement, especially one you might think is a little unfair. But it's their case, right? It's the
even if it is unfair,
Yeah,
right?
the parties
The
have a right.
mediator is going to let you if they believe you're doing it of your own free will. They're not going to like, are you sure? We're not going to do that, right?
Yes.
And so that also, I'm sorry to interrupt you, Matt,
That's good.
right? You can have an attorney review that agreement before you sign it, right? You can get legal advice before, during, or after. If you ask, the mediator is not going to force you to sign. Now, we like to get agreements signed right then and there, but we can't always sometimes. And if someone says, "Ooh, I want to show this to somebody," do it. Maybe that's a good idea too.
No, I would add a disclaimer for certain jurisdictions that might not be possible. So you got to make sure that you
can in
check
Florida, but
yeah.
good point.
So in Texas, for example, basically once you've mediated and you sign that dotted line.
No. I'm saying before you sign. I'm not saying
yeah, of course. Before once you've signed, you're done.
Yeah,
Okay.
once you sign, you're done.
But if you are able to talk to the mediator and they can confirm with the other side that the parties can maybe recess the case and then come back, then you might be able to get some help.
So thank you so much, guys. And that will be it for today. I hope that it brings some knowledge to our possible pro se clients, both as lawyers and as mediators, to where and how and when you can go to mediation without having a lawyer. And please stay tuned to learn more in our next editions of this series, Roundtable with Tye Bourdony, and hope to see you soon.
Absolutely. Awesome.
Thanks, guys. Later.